Anybody out there? All right, Melanie, I like it. Okay. I just told my wife that I have so much important stuff to say that I can't continue communicating with her, and she disagreed with me. All right. So the next thing we're going to look at then, we're going to have, not that you have to know every provincial difference, okay? That's not the case at all. But it's good to be aware that there are these substantial provincial differences, and it is examinable. So Sean, here you go. Well, I don't know if Sean's back yet, but anyways, the examinable item would not be what is the rule in Alberta or what is the rule in British Columbia. The examinable item would be that there are differences between the provinces and what impact do those differences have. Okay, good. So that's really what we're concerned with here. So it's not a matter of memorization. It's a matter of seeing where we get these differences. Okay. Now, I'm pretty happy with this chart, actually. I like this as a resource. I think this is something that, especially if you do, like if you're in whatever, Lloydminster, and you do a lot of cross-border work, or if you're in New Brunswick, or if you're in PEI, you know, there's a lot of cross-border work that shows up there, or Nova Scotia for that matter, or in certain parts of BC, then I do like this chart anyways, just for being able to compare these differences, and certainly when clients move back and forth. So, so I don't want to look at every last detail. I want to highlight some of the things that we see that create differences from one set of relationships to the other. So we're going to look at two different sets of tables here. We're going to look at the rights at the end of the marriage, and then we're going to look at defining common law relationships. Okay, so what happens when a relationship ends, and then what defines a common law relationship. Okay, so we see in British Columbia and Alberta both, we see a difference compared to other provinces. In other provinces, when you get married, that revokes your will. But in these two provinces, getting married in particular does not revoke your will. Now, the next column we have, what happens with your will at the end of a relationship. This is one of the places where we will see some differences between common law and married relationships. Okay, and even in terms of the outcomes at the end of married relationships. So in Alberta, when your relationship ends, so I want to be clear here, this goes back to my comments earlier about married, separated, divorced. So if I make a reference to an ex-spouse, what's the requirement there for that person to be removed from my will? Or what does that mean doesn't happen specifically? So how would I get an ex-spouse? That's it, Sean, right? But not by separating. Okay, that's fair. So divorce means you're going to have an ex-spouse. Separation does not. Okay. That's also true, Stephen. All right. Okay. And possibly Todd, although Stephen's path is a little less direct. Okay. All right. That's all good. So then our asset sharing considerations, and I don't want to go into every last detail here. I do want you to recognize that we have different rules, okay? Different rules for different provinces. So just right here, you can see between Alberta and BC, which have a fair bit of overlap, in Alberta, we include business assets, everything acquired or grown since the start of the relationship. BC has the same thing, but then BC also says we're also going to divide any trust assets, and that would be an explicit set of rules. Okay, that's good. Now, the rights that you see on this page are what we would call statutory rights. Okay, and what I mean with that word statutory is we'd actually find them written down in legislation somewhere. Okay. All right. See, the author of that book spells his first name PH, Melanie, and that's, you can tell us the truth there, Melanie, that you've already bought a copy. So those are statutory rights. Okay. Oh, that's so funny, Todd. All right. I don't think it's safe to make that joke, but you go ahead. All right. And then the assets that are not shareable, and you see a big list here, and this is typical. Every province is going to have a few things that are not shareable. Okay. All right. I think you've told us that before. And yeah, again, date of division of assets. So we get these different outcomes. You'll notice some weirdness here. Alberta, so if you actually, what this means in Alberta, if you separate, you with me here? This is a good reason for some avoidance of uncertainty. And there was a big lottery ticket question about this in Alberta a couple of years ago. So in Alberta, what happens here, if you separate, okay, and then later on you divorce, and we don't deal with the division of assets until out here somewhere, which is pretty common, stuff that's acquired in this window is still divisible. Okay, so there's no protection for assets that you acquire. It's a reason, again, to make sure that you firm everything up as quickly as possible. Okay, so once again, I'm not fussy on the particulars. I mean, I live in Alberta, so it matters. I'm not fussy on the particulars here, but rather, where do we see differences? Okay, so you can see here that Manitoba, in Manitoba, this is more like other provinces. Marriage does revoke the will, and this is normal. Alberta and BC are exceptional this way. Okay. Nice, Stephen. All right, and absolutely not, Melanie. Again, what I care about isn't even so much that you can do a per province list, but rather that you recognize what kinds of things differ from province to province. Okay. Nice. Okay. That sounds like bad advice, Grant. Okay. So an exam question would be more general in nature, Melanie. So an exam question might be something to the effect of, in most provinces, okay, there's really two ways you can do this. You can do an in most provinces question, and that's where you'd have to know that most provinces, for example, marriage revokes a will. So you could do in most provinces, and I could do marriage revokes will, okay? Or I could do something like this. And this is a tougher question to write, but it's actually a fair way to do it. I could actually tell you the rules. Okay, this is perfectly fine. And I have a question like this in my CFP prep material. I can tell you the rules and then test you on them. Okay, and that's perfectly fine. Okay, which may not sound that difficult, but honestly, it is. And I can just use the example here of the Tim and Melanie case study. where I tell you exactly how to calculate Tim's minimum credit card balance. Okay, everybody remember that in the Tim and Melanie case study? I tell you exactly what the minimum credit card payment is. Okay, and still about a third of students mess that up. Good. You look in the forum posts, there are ample forum posts about Tim's minimum credit card payment. And somehow, even when I say read the last sentence of the case study, somehow still that doesn't solve it. Okay. So it's kind of that you give the answer, Esther, but really you would build this scenario here. Okay. So you build the scenario so that maybe something isn't obvious, so that you have a little bit of gray area, something like that. Okay. But you're not going to have straight memorization. So what you won't see tested is this couple lives in Ontario and they do this. How does it turn out for them? Good. Okay. And that's why I'm not focusing on, we're not going to look at every province. I just want to show you. Yeah, attention to detail is important. Reading the question is important. Those are two valuable skills here, Esther. It's a true story. Okay. Yeah. Yeah, now, Bev, that being said, and we're going to see different versions of this. And again, this is a good place to recognize a provincial difference. You notice that in Manitoba, not every province allows this, but in Manitoba, you can write your will in contemplation of marriage. So you can say, we know we're going to get married. We're not married yet. So you can write the will in contemplation of marriage and it will survive then. Okay. Good. And if you really had an engaged couple like that, Bev, the lawyer would write the will in contemplation of marriage. And in Manitoba, that would work out just fine. Okay. So not in most provinces, Ksenia, all right? There is one province where that's exceptional though. But yeah, and you would exactly see that detail here if that were the case. So in Manitoba, becoming common law doesn't change your will. If it did, I would mention it here, and you're going to see that in a couple minutes when we get to the S's. All right. Okay, can we keep going here? Like I said, I don't want to look at every last detail. Okay, oh, something interesting actually in Manitoba. Exactly that, Grant, defined benefit pension plans. There's a real concern there. Manitoba has this thing that you don't see very much of, where cash surrender value of a life insurance policy is generally not a divisible asset. Good. And I think we know in most provinces that inheritances are generally not divisible. Okay. And I'll point out that income and gains, this is a variable item. So this one varies by province. Sometimes we include income and gains and sometimes we exclude them. You have to look at the provincial variations to know that. Right. So you don't need to worry about, in Manitoba, Stephen, you don't need to worry about acquired prior, because if you brought it into the relationship, then it's also not divisible. Okay. So acquired prior would sort of be the primary concern there. And then the fact that it's an inheritance would be secondary. Good. All right. Okay. New Brunswick. I don't think there's anything exceptional to point out in New Brunswick.
Jason, what about the commingling of assets, like the inheritance?
Right.
As long as
So
it's
what you're generally going to see, where's an inheritance rule? We don't have an inheritance rule here. When I get to, we'll do Newfoundland and I'll show you the inheritance thing, Todd. Okay. So not that New Brunswick is not special. I'm not trying to carve out New Brunswick here. Just New Brunswick has a fairly middle of the road set of rules. There's kind of nothing weird in New Brunswick. Okay. Although actually the one weird thing in New Brunswick that I will point out, no protection for inheritances. Okay. Oh, sorry, I apologize. There is protection for gifts though, which would normally include an inheritance. Sorry. All right. Newfoundland and Labrador. So this is where you see the gift or inheritance received by one spouse or partner, including growth and value. Okay. So what has to happen here, Todd is right, is that generally will break down if you commingle the asset. And commingling is a tougher issue. So this would be a question of fact. If we look at how you treated it, we say, well, you kept it in your own bank account. So that's a good thing. Okay. And that's kind of the question here, Shauna, right? So you kept it in your bank account. So that's a good thing. But you drew from that bank account every month to pay down the mortgage. Well, did you now commingle the asset? Were you using it like a matrimonial asset? And that might, and I'm not going to say will, I'm going to say that might undo any protections for that inheritance. Okay, maybe, that's right. That would be a question for the courts. And you'd find questions like that always operating on sort of a pendulum, where this year we might say, yeah, the courts are more prone to protect inheritances, but then we get a couple of rulings from the Court of Appeal and it pushes the pendulum the other way. So you can even get it where what was true in 2010 is not true anymore in 2020. Okay, and I would say that today, in general, the pendulum has swung pretty far against the protection of inheritances. Okay, so inheritances are extremely difficult to protect today. Any of you at Investors Group who have gone and watched Christine von Kauenberg speak, I'm sure you've heard her talk about this, right? I know it's a favorite topic of hers, is the difficulty of protecting inheritances. And I know she has a different version of that presentation in every province. I've seen it in Alberta and Ontario. Okay. Yeah, and I'm not wrong here, am I, Grant? You see her speak. She often speaks about protecting inheritances and the difficulty therein. Yes. Okay. All good. Incidentally, this chart is actually culled from her book. I do give appropriate credit in the chapter, but yeah, her book was super helpful in building this chart. All right, Nova Scotia is one that we want to focus on. Nova Scotia does have a rule that sets it apart substantially from other provinces. Okay, and what you'll see in Nova Scotia is that unlike other provinces, we are also going to include in the division of assets, what's the unusual consideration here? Why don't I get rid of that? So in Nova Scotia, you have no protection for stuff you brought into the relationship. Normally, when you bring property into the relationship, at least that base value and sometimes the increase in value is excluded. But Nova Scotia notably has no provision for that. Good. Right, so the right is just the next column over. See? All are shareable except what's on the right, which is the assets that are not shareable. Okay, so that stuff is all on the right. Okay. Good, that's to the right, isn't it, Todd? Okay. And then Nunavut just borrowed all of Northwest Territories rules. Ontario has a couple of weird things. Yeah, a couple of things to point out in Ontario that set it apart from other provinces. Notably, Ontario has this sort of timing provision you have to respect, where if you have a death that happens after a relationship ended, you can sort of elect in or elect out of the property sharing regime. And the big thing here in Ontario that's different from other provinces is that if you bring a home into the relationship, the home is divisible. Okay. In other provinces, we would normally carve the home out if it was an asset you brought into the marriage. Okay. Right, so it has to be the matrimonial home. If it was no longer the matrimonial home, then it no longer would have that protection, or it would no longer have that provision. So now if you had 3 or 4 houses during the time that you're married, Todd, it would be still just the house that you're living in at the time of separation.
Right, but if you had a house you were living in and then you got married, you then take that property and you could make that a rental property. And then the new home that you move into, that would be the matrimonial home. So the original property you owned before, you turn it into a rental, you wouldn't have to split that with your spouse.
I don't know that. I don't know if I'm comfortable making that determination. I would want to leave that to the family lawyer.
Okay, I'm just reading what's there, and when I read that, that's what it means. So I don't know.
I think you have to interpret that a certain way to come to that meaning, because you're assuming matrimonial home on the date of separation. I could apply that to matrimonial home on the date of marriage, right? So I honestly don't know. We could go and read the legislation. I don't think we want to, but we could. And you'll note that Ontario does not have sharing of CPP benefits. Okay. Okay. Yeah, that's true, Melanie. Okay. That's a true story. Yeah, or that's good planning, Shauna. One of the two. Okay, might be sad, or it might just be good planning. All right. No. Okay. But yes, you hope the people aren't thinking about this stuff too much when they get together, right? Okay. PEI. I think PEI very similar to New Brunswick, just sort of right up the middle mostly. It's Saskatchewan. Oh, I guess I have this rule later on for Saskatchewan. We'll talk later on about common law relationships in Saskatchewan. Yeah, I think that that's a reasonable thing to do, Stephen, to at least have some financial, like, I think that not so much this stuff, but I think there's a benefit to just having a couple talk about money before they get together. Just, are you on the same page money-wise at all? Right, and I think that's something people don't talk about. Yeah, exactly, Stephen. So yeah, bring your money scripts into your church, Stephen, right? Something like that. Okay. Yeah, I can. And you have access to this in the chapter, Melanie. All right. So this is right in chapter 5. Yes. Yeah. Net value of what you brought in is not shareable. Okay. The question about net value in general, Melanie, is actually a difficult one. So I know how this works in Alberta, for example. I have read the act in Alberta. And what we say, basically the Alberta matrimonial property regime makes no reference to debt. Okay. So the question of net value is not addressed in legislation because the assumption is that a couple going through a separation is going to be able to address those issues as two adults just working through their stuff. Does that sound like a true story? But that really is what happens. We make no reference to debt because we figure whatever, they'll get it sorted out. I mean, you'd really have to be planning it out, Grant, but yeah. Okay. Now, I'll point out in Saskatchewan, yeah, although this is now on hold because of COVID, so I don't know what's going to happen here with COVID, but yes, there was supposed to be a rewrite because right now in Saskatchewan, for example, no exception for gifts or inheritances, okay, which you may be aware of. Bev, I know that's a big deal in farming communities. So gifts or inheritances in Saskatchewan are divisible assets, okay? And the other thing that's different is when you become, and we'll see this in the bottom of this page, or the bottom of this handout, when you become common law in Saskatchewan, that scraps your existing will and power of attorney. So those are things that I know that the Saskatchewan, and now you have an election, so I don't know what, no idea what's going to happen here with this between COVID and the election. Okay. I mentioned status Indians here, not that it's particularly helpful because everything is variable, but generally what you're going to see, this is not universally true. Many reserves will have defaulted. They'll say, instead of us having our own rules, we're going to use the provincial rules. And that's often better because you get at least a well-defined set of rules. Otherwise, you're often defaulting to the Indian Act, which is a difficult bit of legislation. Okay, that's good. And the Yukon's weird. It has gone in a completely different direction. There's something in the Yukon that's like nowhere else. You can see you divide everything in the Yukon, okay, except for potentially business assets, and wait for the bottom of common law relationships for the Yukon. Okay, so Alberta, of course, we know no common law. We have adult interdependent partners here. So the questions here that are generally most important for the end of common law are what happens at the end then of this common law relationship. So do you have estate rights? And you'll see this is variable, okay? Do we have division of assets? Okay, we'll see this is variable. Spousal support, I believe Yukon is the only territory that doesn't do this. Impact on your will, what happens with a will when you enter into a common law relationship, and what happens to your will if a common law relationship ends. Okay, so Alberta, pretty straightforward. We just had a rewrite of our estate legislation, which brought these rights to common law couples. You can see right off the top here, I said these were different from province to province. So BC says 2 years for common law. Alberta says 3 years for common law. Okay. Manitoba goes to 3 years as well. And again, you can register that relationship earlier in Manitoba. Okay. You can see in New Brunswick, 3 years normally, but you short circuit that if you raise a child together. Curiously, though, unlike the Canada Pension Plan rules, this time the child has to be both of the parents' biological child. Okay. Now I want to just lock this language in. I'll explain what this means in a few minutes. So do you see in New Brunswick, there are no estate rights on death, okay? There's no legislated rights, but there is a dependence relief claim available. Okay, so let's talk about that more in a couple of minutes. This is where we're going to talk about statutory rights. versus non-statutory rights. So let's lock in this New Brunswick picture so that when we pop back into PowerPoint, we can have a look at statutory rights versus non-statutory rights. Okay. Again, though, Stephen, it's not a matter of knowing every in and out, right? It's a matter of knowing that there are these kinds of differences. Okay. So I really produce this as a reference document more than as something to explicitly study from. But when you look through it, you'll see that there are these big differences. Okay. So I don't remember what I wrote, Stephen. Sorry. All right. Number of years doesn't matter. That's true, Shade. Yeah. All the question would only be, are they living together and raising a child together? Okay. All right. You can see Newfoundland basically has the same rule, 2 years, but then they add an adopted child as well. And you'll note that no division of assets in New Brunswick or Newfoundland at the end of a common law relationship. Okay. For whatever funny reason, NWT and Newfoundland have the same rules. And except, sorry, for the defining the relationship, Northwest Territories, however, like Alberta, says, yes, there is going to be estate rights and division of assets at the end of a relationship. Okay, Nova Scotia. Nova Scotia is a little bit problematic here because you don't have default rights. You have to register your relationship in order to have any sort of rights. Okay. Other than that, you could be common law, but it does not matter. All right. Now, if you do register your relationship, now we get yeses for rights on death, division of assets, and spousal support. Okay. And you'll notice Ontario gives us once again that dependence relief claim. Okay. So again, be prepared for that. We're going to talk about dependence relief claims in a couple minutes here. All right. Any questions there? I guess so, Esther. Yeah, there should be like a Move to Nova Scotia campaign, Esther. We have a little song with it. Couples moving there and then separating, one of them happily, one of them not, something like that. All right. So PEI, we're back to 3 years or raising the child together. You do have estate rights on death, but no division of assets. So again, just to show that this is different in every province. Okay, Saskatchewan. So this is what I had mentioned. That's a little different. That when you enter into a common law relationship in Saskatchewan, and Bev, this was kind of your question earlier, right? That's a big deal. Okay, that's a really complicated outcome because you'll have people who stumble into common law relationships unwittingly, and it may end up destroying an existing will. Okay, good. Perfect. That's where I thought Grant was going to come back with, unlike marriage, which just destroys your will to live. But all right, but Grant wasn't there for us. Okay, and then Yukon. So Yukon, I had said this earlier, is a nightmare here, and everything is different by its own statute. There's no overriding legislation in the Yukon. So you really have to look at every individual statute to determine how this is going to work. Okay. Nicely done, Grant. All right. And the other thing you'll notice in the Yukon is no rights for same-sex couples. And that's exceptional. I don't know how that's still true in the Yukon, but that's still true in the Yukon. All right. That's all good. So I guess, Esther, we could have another sort of relationship or another like tourism campaign where you can encourage same-sex couples where one of them is rich and the other one's not to move to the Yukon. Good. To protect their property. Okay. Perfect. Any general questions there? Okay, let's pop back to PowerPoint then. Again, you have access to that document right in the course documents for today. We already looked at our relationship overview. Okay. It's true, but that doesn't necessarily mean that it falls under the Indian Act, Bonnie, right? Remember I said that a lot of reserve communities have elected to use their provincial law. Okay. Well, so I agree with you, Todd, except that we have to know when to send somebody to the lawyer, right? And there is some navigation that has to happen here with the financial planner. Okay, so we just showed this. Basically, statutory rights is anything that's written in legislation. So if I can go into the law, I find it written down, that's what we would refer to as statutory rights. Okay, good. And most of what we saw on that last document would fall into that realm of statutory rights. Okay. Yep. It means that we can pop over to the BC Matrimonial Property Act and have a look at a specific answer to a specific question. That's a statutory right. On the other hand, then we have what are called non-statutory rights. So do you remember I said, let's lock in for Ontario and New Brunswick, that idea that at the end of a common law relationship, there's no statutory rights. However, we saw the possibility of a dependent relief claim. Okay, now we're going to see these dependence relief claims again in chapter 6. Basically, under a dependence relief claim, you're saying, look, that person died and they left me without. And the sort of strength of your what they left me without is how you're going to enforce your rights. So the question here is, what did they leave you without? Did they leave you without income? Did they leave you without some sort of property, without a house to live in, whatever it is, okay? And you're going to build a claim on that basis. Does that make sense? Now, who are you going to be building that claim against? Oh, sorry, I don't want to say died. Your partner didn't, we're going to deal with that tomorrow, or Friday. Your partner left you. There, okay. So that would be true, Stephen, if I had stuck with died, but I took died out for exactly that reason. That was confusing. So what you're going to do here is you fight essentially with your partner. You say, hey, you're supposed to leave me with something instead of just leaving me out in the cold. Okay. So it's going to be this question for the courts to determine the strength of that claim. And on that basis, they might award a division of property, or they might award even possibly spousal support in some cases. All right, that's good. Now, you're actually right, Stephen, in the sense that you're far more likely to see a non-statutory claim in an estate law case than in a family law case. There's lots more opportunity for that with estate law. Okay, is everybody with me on the difference between statutory and non-statutory rights? Okay, so that's our dependent relief claims. That's exactly what we just looked at. Now, we also have to have a look at the concept of a constructive trust. So this is a form of non-statutory relief that can apply both to married and common law relationships. Okay, and as examples of something that might fall under a constructive trust relationship, we would see this applied to, and I'm going to give you a specific example in a minute, we'd see this applied to business assets, which are otherwise exempt in some cases, and inheritances. These are two places where a constructive trust claim could arise. So, we have a fairly well-known case here, okay? A 1993 British Columbia case. And this case went to the Supreme Court of Canada, okay? And the case is called Peter v. Biblo. And what happened in this instance was that Peter was the ex-common law partner to Biblo. Okay, and so Biblo owned a hunting camp. This was the business, okay? And Peter gave up, the idea here was Peter gave up her economic opportunity, or at least this is the argument, to take care of the household while Biblo went out and built a business. Okay. And what was Peter counting on in exchange for that? What was the sort of unspoken promise? Yeah, that's right. Their last names, always last names in court cases, Esther, right? Okay. So what's the unspoken promise here? If you stay home and take care of the household while your spouse goes and builds the business, yeah, exactly, Sean. So the assumption or the unspoken promise here is that one day he would sell the hunting camp and fund their retirement, right? That she would be included in the value of that asset. Okay. Yeah, I think that that is a fair assumption to make, isn't it, Todd? Okay, that she wasn't thinking he's going to sell the camp and just pay for his own retirement, right? She figures that this is what's going to happen. So they were together for a long time, for 23 or 24 years, okay? And at the end of that relationship, she makes a successful claim that he built this property or built this arrangement in trust for both of them. And on that basis, even though it's a business asset, which we would normally exclude, it gets brought into the discussion. And this is what we would refer to then as a non-statutory claim. I don't think there were any kids, Esther. Oh, just hang on a second. Maybe there were. I get 24 hits on children. Yep. Oh, blended family. I don't know if they had any kids together, but they raised children together. Okay, I think it might have been a Brady Bunch scenario. All right. All good? Okay. And today, this has become a very common argument. Okay. You will see lots and lots of cases that just default right to constructive trust. Okay. We often don't have to go to court for it. The lawyers involved will just say, yeah, that's what the courts are going to do. There's no point in fighting about it. Okay. Now, another non-statutory agreement, or sorry, non-statutory argument we can make is around unjust enrichment. And in fact, this might show up in the scenario you had presented, Grant, right? So Grant, half joking, said, give everything to your parents, and then after you separate, or have them give it back to you and then separate, right? But an unjust enrichment argument would potentially prevent that kind of thing from working. Sorry, Grant. So what we're going to do here is we say, you had an asset that was really ours. Okay. You gave that asset away or promised it to somebody. You treated it as yours. And now I'm going to go after that person for that unjust enrichment. Is everybody with me there? Now, this is very common in estate cases. It's not as common in separation cases, but it does happen. Okay. All right, and our last family law slide that we have to deal with concerns inheritances. So we want to look at getting an inheritance into the hands of the children and having the opportunity to have it protected. Can we do this? Is it even possible? And we can look at a bunch of different outcomes here. So mom and dad, they have property, whatever that property is, doesn't really matter. And we're going to pass it to the next generation. So we have, we'll give them just one child, their sole child, Alex. Oh, we'll give Alan, so we're clear about gender. All right, so we have Alan here, and Alan is married to Barbara. Okay, and what we want to do here is mom and dad say, we want that property to be delivered to Alan and to retain its character as an inheritance, and really to have no opportunity here that if Barbara should ever decide to leave our precious, precious Alan, that she would have no way to get those assets. That's good? Okay. I don't think the school across the street from me is shut down. See no kids today. Only half the teachers are there. All right. Yeah. All right. My wife just reminded me it could be, even though it's only like, oh, so it must be the same thing here, Sherry. PD day. All right. There we go. So early in the year for PD day. Oh, yeah. I guess it's the end of October. All right. We're like having a disagreement here from down the hall. So, okay. Sounds like no COVID. So I find it crazy, Carla. All right. So there you go, Grant. All right. No, I don't think that's true, Esther. All right. So although the hold down the hall thing, I get you. All right, fine. So we want to protect these assets in case the relationship ends. Okay. So we say we don't want Barbara to have any rights, any claim to this. And this is a very difficult thing to do. Okay. It's almost impossible to make this bulletproof. And yeah, the cottage is a great example here. I think, was that your examples? You mentioned the cottage, Shauna, for the cottage, right? So yeah, the cottage, and often that's the one where we do this, but it's going to be almost impossible to be bulletproof here. Okay, we know that Saskatchewan already offers no protections here. So forget about it in Saskatchewan. Okay, so we say, what can we do? What can be done to enhance this protection? Well, I would suggest step number one. The number one thing you can do, don't get married. That's true. Number one cure for prevention of divorce, right? So that's my wife down the hall again. So the number one thing you can do is have them write a prenup or postnup, wherever they are in their relationship, have them write some sort of marriage contracts. Okay. Good. I'll tell her that my students think she's hilarious. All right. So we have them write a prenup or a postnup, and this has to be, though, bulletproof. This has to be really well done. So there has to be a disclosure of all material facts. So for example, okay, if, oh, interesting, Bonnie. Yeah, okay. So are they wealthy? Are they a wealthy family, Bonnie? Okay. And so they set this requirement, right? They set expectations early, I'm assuming, Bonnie. They said, if you're ever going to enter into relationships, here's what's got to happen, right? They're very clear about it. They probably have a lawyer that everybody goes to. Okay. Oh, interesting. So if she hasn't signed it, that's, yeah. All right. Okay. Got it. So she knows that's going to come up at some point, eh? And I find, generally speaking, with good prenups, it's not like she's going to be left with nothing. A good prenup, one that the courts will accept, generally will still leave her in a fairly comfortable position. It just doesn't give her full access to everything. Okay. And this is a valid point. So there has to be complete disclosure. If we know we're going to get this inheritance and Alan brings Barbara the prenup and says, hey, hon, can you sign this? And there's no discussion of the inheritance, the courts will unwind it. Okay. That's good. So we need that full disclosure. I think still boyfriend at this point, Bev, but I think around the corner from common law, it sounds like, eh? Okay. Well, that being said, Betty, I think there's also something to be said for having the relationship and then not having to worry about that whole what if set of scenarios. Okay. So we want disclosure of all material facts. We want legal advice for both parties. And there has to at least be an element of fairness. That doesn't have to necessarily be equal, but we can't seriously disadvantage one party here. Okay. Does that all make sense? So that would be the number one thing. Now, there are things we can do on top of that. So number two is we make it clear that it's inheritance. Okay, so if it's left in a will or whatever it is, that we're very bulletproof clear, language in the will or whatever other document is very clear about this. Okay, so we say it's always intended to be an inheritance. Well, that's kind of the thing you're trying to get around here, Esther, right? We're trying to protect the cottage from that language. Okay. So we want to make it, and then as we've already heard, we want to make sure that, I think Shauna mentioned this, that, or maybe it was Todd, but we want to make sure it retains its character as an inheritance. Okay, so that it doesn't get commingled, all that good stuff we talked about before. Okay. Yeah, that's often the case, Bonnie. I know I presented here as protecting from Barbara, but there's more to it than that, right? And then the number three thing that we can do potentially, and this varies by province, you may be able to use a trust. Okay, this is highly variable, but basically what you're doing with a trust is you're limiting Alan's rights to that property Okay, so if I can close Alan's rights to the property, then then Barbara may have a less of an argument for her rights to it. Okay, so as long as we use a trust here that potentially gives Alan some rights but not full rights, that can impede Barbara's ability to go after that property. So what's the timing here, Bev? What are you thinking in terms of timing here? Like, so generally speaking, Bev, the law holds that you have to, and this varies by province, but the law generally holds, and this is much the same as property and casualty insurance claims, we talked about that last time, the law generally says that you have to pursue legal action within 2 years of finding out that there was harm. Okay. So in a case like that, Bev, yeah, if you didn't find out until a couple of years later that your spouse had some asset or had some money that you didn't know about, as long as you sought legal action within that period after discovering that harm, then you're probably okay. Now, Bev, that's where, if you actually end up in that situation, you're going to go to court. And one of the first defenses the other party will use is to say, well, you should reasonably have known about it when this happened, right? Yeah, I don't think so. The finding out thing is really the key there, Bev, right? It's when did you find out, or when should you reasonably have known? Yeah, again, it's that you know, when do you discover the harm, right? Okay. All good? I don't know if you remember, Bev, in core curriculum, we talked about the McCain Family Trust. Do you remember that thing? And in that case, she sought relief 10 or 11 years after the agreement was signed. So that's the big French fry family, right? Actually, this was the Maple Leaf Food side. Yeah, the French fry. No, the Maple Leaf Food side, I apologize. And in 1985, if I remember right, you can go look it up, it's all public. But in 1985, they had signed a postnup. And when she signed the postnup, there was no disclosure about his interest in a family trust that was worth, I don't know, at the time, like $1 billion. It ended up being worth like $4 billion. Okay. And then 11 years later, they separated. And that's when she came forward with her claim to say, I didn't know about that asset. And it really was the date of discovery that she was able to use as her basis for when harm was done. Okay. That's good. And I know somebody remembers this. Because of that, she was able to get the amount of spousal support changed. The spousal support was supposed to be $32,000 a month, and it ended up getting cranked up to $190,000 a month. Okay. All good? Okay, that's a good discovery, Ksenia. Yes. Okay. Yeah, I don't think it's a lost cause, Bev. I would look at least put a call into a family lawyer. Okay. Okay. If you feel like it was significant, and especially you're trying to raise 5 kids, all that good stuff, I would really watch that. Okay. Yeah, good. All right. Any family law questions? Again, not a comprehensive look at family law. We just wanted to cover off some of those provincial differences and variations. All right. Now, we did touch on this back in core, but technically, and this is actually one of the few things that I disagree with in the organization of the course, excuse me, is the principal residence exemption. So the principal residence exemption is properly only examinable on the CFP exam, not on QAFP, which I think is completely bizarre, but what do I know? So anyways, the exemption here, the idea is it allows, of course, the sale of your principal residence or the disposition of your principal residence with no tax consequences. Okay. First thing we should do then is define what a principal residence is. So what constitutes principal residence? Well, we would have, first off, it has to be ordinarily inhabited in the year. Now that rule is actually not particularly well defined. Generally, what that means is that you have to have lived in it for at least some period. However, there's no definition anywhere of what that period is. And I've heard all kinds of different versions of this. Pretty much everything you hear around this is just a myth. It's not one day in the year. It's not 6 weeks or 6 months or something like that. The rule is just that you have to have lived in it for some period. So generally what this means, this precludes a property that you rented for the entire year. Okay, that's definitely out. good? So it has to have been ordinarily inhabited. So yeah, ordinarily inhabited, it can be outside Canada. Your principal residence does not have to be in Canada. However, there are some reasons not to use the exemption for a property located outside Canada. Remember, though, that under Canadian income tax law, your okay, so I'll show you that in a second, Melanie. You're right about the 4 years thing. Okay. We'll come back to that in a minute. So there is a little bit of an exception for rental, but to use that, you have to still have principal residence on either side of that 4 years, or at least on one side of that 4 years. So yeah, we'll talk about that right away. It's a good question. So it can be outside Canada. And for farmland, we're generally looking at the smallest subdividable lot. The Income Tax Act says half a hectare, but often, especially in Western Canada, half a hectare is a lot smaller than what you can actually find for farmland. Okay. All right. Now, what happens here is you declare one principal residence per year, and that the capital gain on that property is then wiped out for that year. Okay. The capital gain for that year on that property. Okay. So you don't necessarily have to be sort of consistent in your application of the exemption, but it's generally easiest to do something like this. So let's say that I acquire a house in 2010 for, let's say, $300,000. Okay. And then I dispose of it in 2020 for, let's say, $500,000. Okay, that's good. Everybody's with me there? So what I would do when I sell it in 2020, I declare it as my principal residence. And now I have to actually file this on a Schedule 3. So it's my principal residence for the following years: 2010, 2011, 2012, 2013, 2014, 2015, I'm almost done, 2016, 2017, 2018, and 2019. I specifically don't have to worry about 2020 exactly that, Todd, because the +1 rule. Because what the formula actually does for me, the principal residence formula, we're going to take the years that it was your principal residence +1 divided by the years owned, and that tells you how much the exemption is. Okay, so in this case, how many years did I declare this as my principal residence? $10 years. And how many years did I own it? $11 years, right? I would have to add 2020 into those years owned. Okay. And I know it was tedious watching me write out those 10 years, but this is what you should be doing on the exam. Okay. Is manually counting out the years like that. It's the safe way to do it. It's what I did on my exam. It paid off. Okay. It's the right thing to do. It'll save you a lot of trouble. So, because at least for me, now maybe your math is better than mine, Todd, but at least for me, those inclusive years I always find difficult. Okay. So I have to count them all out like that, 2010, 11, 12, 13, because normally with this kind of question, I would be dealing with 10 years, right? If I normally think about a question like this, 2020, 2010, that's normally 10 years, right? Because I'm using every portion of the year, Melanie. So if I bought the house in December of 2010 and disposed of it in February of 2020, that's still 11 years in which I had that place as my principal residence. Okay. Is that what you're asking me? Or you just
I use my fingers.
Sorry?
I count on my fingers.
Yeah, that's what, honestly, that's what I did on my exam too. Okay?
I do that too.
All right. So, but okay, so Melanie, are you with me that there was 11 years in which it was owned? It was owned in a portion of 10 and a portion of 20?
Yep.
Okay, perfect. So as long as you're good there, don't worry then about my crazy math. All right. If you know that's 11 years and you can live with that, I'm fine. If you don't
Okay,
count on your
so-
fingers, I'm not going to track you down on your exam or anything like that.
No, I'm just thinking like, instead of counting on fingers, because let's be real, it takes a bit of time. Like, can you not just do 2020 minus 2010 plus 1?
If you're good with that, go ahead. Yeah.
Okay.
I will always count out the years. I find it's the easier way to track something like this.
Okay.
All right. No portions of years. So it's any portion. So what's happened now is I've used my exemption for those 10 years.
Yeah, but when you're counting years of PR plus 1, so if you count on your fingers, 2010, 11, 12, 19, you also own it in 2020. It's not a full year.
Right.
So you don't count 2020.
I do count 2020 because I don't need to have full years. 2010 was also not a full year. I bought it in December of 2010, right?
But then why are you putting years of principal residence 10?
Because I had it in 2000. No, I did. I used 2000. I used 10 years. That's literally, I have 10 years in that red box, right?
Yes, but you're saying that you include 2020, and I'm saying you don't because you disposed of it that year.
But you do include 2020. Just not, I don't need to include 2020 in my count because I don't need 11 in the formula. I only need 10 in the formula.
Yeah, but
So
I'm saying it's different. Years owned and years of principal residence. Years of principal residence is 10 full years, but it's years owned because you still count 2020, but you wouldn't count that as a year of principal residence. That's what I'm saying.
I don't have to because of the +1 in the formula.
Right, but I'm just saying, isn't that the correct math, what I said?
I don't know how what you said and what I said are any different. It's no, okay, not full year. No, it has nothing to do with full year, Todd. You had it right when you started at the beginning. You said because the +1 in the formula. That's
Right,
why
I know that, but I'm just don't understand why we say it's years of principal residence and years owned. Why are they not the same?
Okay, so I'm going to add another property in here and then you'll see that.
Okay.
Okay, and it does not have to be consecutive years. Okay. Okay, it does not have to be consecutive years. It's only convoluted, Melanie, because like owning something from January 1st to whatever, February 28th in a year is not a year, right? But for tax purposes, it is a year. Okay. So again, though, Stephen, it doesn't matter what years it was my principal residence for, because do you see, I'm not picking and choosing where the gain happened, right? So it might have been, Stephen, and in fact, Alberta is a great example of this today. If we were having this discussion in Alberta, what really happened is your actual fair market value of the property would have looked something like this. You with me here? but I still have to use the blue line for the purpose of my PR exemption. So I can't kind of pick and choose when it was my, oh, so that's, I guess I just don't know why you would do that, right? If it's my principal residence for 5 years, it's my principal residence for 5 years, and a portion of the gain might not be. And I'll show you here. I think having another example alongside this will help. Okay, so here's what happened. This same family, okay, the same family, in 2014, they went and bought a cottage. Everybody's with me here? And they used it as a vacation property, spent extended periods of time there, all that good stuff, until let's say 2023, and they sold it in 2023. Everybody's with me here? So now they acquire in 2014 for, let's say, 280,000. Okay. And they dispose of it in 2020 for, let's say, 600,000. Sorry, 2023 for 600,000. Okay. Everybody's with me here? And again, that gain is assumed to be linear. So their PR formula for this other property is going to be just a little bit different. Still the same formula, I shouldn't say that. The formula is still the same. So now you would look at the years of principal residence plus 1 divided by the years owned. So now, can they use 2014? Can they make this property exempt for 2014? They already used 2014. They already used all the years from 14 to 19.
Oh, I thought we were starting from 0 again. I wasn't including the left.
No, it's the same family. All right, so they already used 2014, 2019. So then they're going to exempt just the years 2020, 2021, 2022, and 2023. So exactly that, 4 years. Do you see that's where, Todd, the portion of a year doesn't matter, right? They owned it for a portion of a year, that's a year. So and how many years did they own it for? What's the total number of years owned? What year did they acquire it? 10 years, Shay, thanks. So we would do that times our gain of $320,000.
You want winter tires?
Okay,
There,
he
there's our-
quoted us at 2K for rims and Michelin's.
Okay.
So yeah,
All right. Sorry, I thought that was Todd. All right, that was not. All right, 160,000. Okay. So $160,000 of exemption here. Okay. Good stuff. All right. Yep, it's a perfect time for it, Stephen.
Perfect, and it's not about tires. I'm just wondering, I was just on the same track as Melanie until I thought about it with the calculator. Like 2023 minus 2020 is 3 years on a calculator,
Right.
right? And it seems like that's where it's not making sense. And I was saying, even if you had to count your years, what if it was 2020, 2021, and you skipped 2022 and it was 2023? But you can't just throw that in the calculator either. 2023 minus 2020, it doesn't.
You're still just tallying up the years that it was exempt, right?
Right, but if they're not consecutive, you can't just subtract numbers. You got to count them on your fingers, really.
Yeah, although it would be weird not to have them consecutive. That would be
Sure.
yeah. Now
Okay.
you could have it where like you had this cottage and then in the meantime you bought a house in 2018 and sold it in 2020, right? Something like that.
Right. Okay.
Okay. So is everybody good with this first part? Okay, now I'm going to come back to something. Oh, and I will just mention one other thing here. If you're a non-resident of Canada, you don't get the +1 in the formula. Okay, so non-residents don't get the +1. So they don't have to have moved into it, Sherry, right? Sorry, I'll come back to your comment in a second, Alicia. It was their principal residence, or it could have been their principal residence throughout, right? That's not saying that they spent every night there or whatever the case is. It's just ordinarily inhabited. Okay. Right, I didn't need to use 2020. That's the whole point, Alicia, right? I didn't need to use 2020 on the left side because I already had enough years to exempt the full gain. Are you with me there? Okay, so the +1 allowed them to leave 2020 out and basically save the 2020 exemption and apply it against the cottage. Okay. So Sean, they only used the exemption, which is the growth for that year. Yeah, that's it, Melanie, right? They only used the exemption for the house for 2010 to 2019 inclusive, right? They didn't need to use the exemption for 2020, so they really preserved it for the cottage. Now, what they could have done here, Sean, when they sold the house, they could have said, well, we think the gain on the cottage is going to be much larger. Are you with me here? So they could have said, we're only going to use the exemption on the house until 2014. And then we're going to save everything from 2015 on for the cottage. You with me? So they could have willfully chosen to pay some capital gains on the disposition of the house in order to preserve more exemption for the cottage. Okay. Are you with me there? Is everybody good with that? So you could have 2 properties in a year, either of which could qualify as your principal residence. You just have to choose which one is your principal residence when you dispose of them. Only if there was some manipulation here, Stephen. There would only be a problem with this if it really looked like they were trying to manipulate the rules. Okay. The biggest example of that, the place where you actually will see that, is house flippers. Okay. CRA has taken a real shine to house flippers here. People who might live in a house for 2 or 3 years, or even people who never live in a house at all and try to use the principal residence exemption for it. Okay. If you sort of, and 2 or 3 years is long enough, probably I should say maybe a year or 2. If you have somebody who just is continually flipping houses, eventually we're going to say, hang on a second, those aren't even capital gains. That's an apple tree problem. And you're going to end up taxed as if it's business income. You with me there? And you will see the occasional, it's a lot of condos where you see this, Stephen, a lot of condos on pre-bought plans where people say that was my PR for the year. And then Siri comes back and says, but you never even put furniture in there. And you get this whole disagreement then. Go ahead, Melanie. Yeah.
So just because I remember us talking about the PRE before and claiming it only for certain years that you inhabited it. And then somebody just asked there about, do I really have to live there? So are you saying that, like, even though we don't live in our cottage, and I probably wouldn't claim it there anyway, just because our house is worth a lot more than it. But let's just say that it wasn't, and we live in our house, and then one day we want to sell the cottage. You're saying that we could potentially like get away with it, or would CRA not know because of the address on our tax returns?
No, there's nothing. As long as your cottage is a place that, and I know you don't winterize your cottage, right? You told us that last
No.
week.
No.
Okay. But you could ordinarily inhabit it still. You live there through the summers, you spend whatever amount of time there, right? There's not like a number of days that constitutes ordinarily inhabit. The fact
Okay.
is you're not renting it out year round.
Right.
So you could use it as your principal residence.
Okay, perfect. So it really doesn't matter what your, let's say, address on CRA is. It really is, you own multiple properties. You can pick the one as long as it's not like full rental.
Yeah, that's right.
Okay, thanks.
Yeah. Okay. So CRA Sherry has gotten more aggressive about the application of the principal residence rules. And a big part of that, Sherry, I don't know if you remember this or not, but in 2017, might have been 16, might have been 15. I don't remember now. But anyways, we added a requirement that you have to show on your tax return when you're using the principal residence exemption. So it used to be that there was no reporting for use of your principal residence exemption. But the fact that now you have to report that has really changed how people do this. Yeah, so Sean, that's exactly the kind of person that the change to the reporting requirements was designed to capture. This person who's got sort of a cabal of family members where you're trying to multiply that PR exemption, right? There's no practical, okay, that's not right. There's no legislated limit, Bev, okay? But if you did move into a new house every single year, like a old school house flipper, right? Eventually CRA is going to come back with the apple tree argument, where they're going to say, that's not even a capital gain, that's business income. And because it's not a capital gain, then it doesn't matter if it's your principal residence or not, it's business income. You're just going to pay tax on business income. Good? Okay. Questions? All right, we'll just do one more principal residence scenario here. And this is the one Melanie had mentioned already. But yes, this is true. If you have a place that's your principal residence, let's say for the sake of argument, you were living here from 2010. Yeah, there's some legitimate tax planning that goes into that. So to your question, Melanie, if you looked at this and for whatever reason, I don't know, the lake or river you're on became suddenly like a celebrity hotspot, and you saw that those values were going to increase substantially, you with me there? And you sold your house in the next couple of years, you would say, no way we're using our principal residence exemption for our house. You would preserve it for the cottage. Yeah. Okay. So from 2010 to 2014, you lived in and inhabited the house. Okay, everybody's with me here. And then for a period from 2015 till a maximum of 2018. So a maximum of 4 years inclusive. That's the most it can be. you could have actually been renting this place out, but it was your principal residence. Okay. So it was your principal residence, and now you sell it. Let's say in 2018, you say, you know what, we're going to get rid of that thing.
Jason, how does that work? How do you say this is my principal residence and you're renting it out?
So you're going to only make that decision when you sell it.
Okay, well, what happens if you have a client that's like that? He lives in it for 4 years.
Yeah.
He then goes and starts renting a condo somewhere and he rents out his principal residence for 30 years. And then 30 years he turns around and sells it. Can he claim that as his principal residence?
Only for the first 4 years that he lived in it.
But how can you rent it out? It says renting this out for a maximum of 4 years. Oh yes. I remember reading that in the text. Okay.
Yeah. So yeah, so he sells it. Okay. And he can exempt now any years from 2010 to 2018 inclusive, because he only rented it out for 4 years. And 4 years is the key. That's right. Okay. That's good. Now, if you're really doing this, if you really have a client in this scenario, or if you yourself are in this scenario, you need to take this to an accountant, because you also have to properly track any depreciation that happens here. And there's a couple of things that have to happen to get your depreciation right. Okay.
Jason, let's say if you own the property and you retire and you're thinking about selling your property and property values are going up during that time, wouldn't it make sense for you to rent the property for 4 years, collect the rental income, and then sell the property?
But where are you living during that time?
You're living up north because you're moving up north. But
Like off
instead
the
of
grid?
selling your property right away, you rent it for 4 years and then sell it, and you could still claim it as your principal residence.
I mean, if you're only strictly thinking from a tax perspective, I can see the logic. I'm not sure if I like the rest of it.
Well, because I have clients that want to sell and move up north, but then if they can't sell right now or they don't want to sell right now, they could rent it out for 4 years. And then if they wanted to sell it then, they could still claim it as a principal residence over those 4 years and
Sure.
not pay
And when they
taxes.
move to Terrace or Prince Rupert or whatever the case is, they're not going to have a property with as much gain on it. So it makes more sense to save that gain for something in the lower mainland.
Yeah, well, they're in the lower mainland right now and they're thinking of moving up north.
Right.
This is what a lot of people are doing.
Sure. Yeah, so that's why I say Prince Rupert
Okay,
Terrace. Right?
okay, go. Keep going.
All right.
You got me thinking.
Okay. Just again, how much work do I want to put into my tax planning, right? That's so yes, I can tax plan around that kind of stuff, but does it actually make me better off, right? Am I? All right. Okay. Any other principal residence exemption? I get that it's the advisor's job to help people make money in the context of what they find reasonable / enjoyable, right? Okay. In the context of what they can tolerate even. Any principal residence exemption questions? Okay. So I want to spend just a couple minutes here, I guess a little bit of time, on some considerations around tax for US persons. Okay. So we've already looked at some income considerations. We already looked at some estate planning considerations. What we're mostly concerned with in this chapter is investment accounts and retirement accounts. Okay. So, oh, and where's Where's Andrew? All right. Andrew and I had a little back and forth about this too already. So anyways, when we look at your non-registered investments, okay, so with non-registered investments, so let's say that I have a, just to be clear here, we're going to have a resident of Canada. Okay, so a resident of Canada, but this person is a US citizen. Okay, they may also be a Canadian citizen. That's completely irrelevant. Okay, so they're non-registered investments. What's going to happen here is they may have some US tax to pay. Well, it matters that they're a Canadian resident for the following accounts. It's not going to matter for the first one, but it's going to matter for what follows. Okay, so they may have US tax to pay. And if they do, then it's a tax credit against their Canadian tax payable. Okay, so generally speaking, there's no extra tax to pay on non-registered investments for my resident of Canada who is a US citizen. Now, that being said, okay, that being said, there may be extra reporting requirements. Okay, and this is where we get into what are called the PIFIC rules, the passive foreign investment company rules. Okay. And this simply is on any sort of mutual fund or segregated fund or exchange traded fund that we may have some additional reporting to do. And really it's that the Americans want to make sure you're not using funds like this as a tax evasion tool. Okay, that's good. All right. Where this gets more complicated, of course, is with our other accounts. So RRSP, so this is so nightmarishly complicated, honestly, Esther. And this is where you have to watch every specific circumstance. But an example will be if you have a Canadian mutual fund that directly holds US investments. Okay, in that case, you may end up having to report to the US tax authorities on the income generated by that particular fund. Okay, so if you really do have a client like this, it's important to talk to your tax team before you build that person's investment portfolio. Okay. I like that question, Stephen. Do you want to maybe ask that again just when we come back from the coffee break? I think that's a fun question. All right. Right, if you're a US tax person, Todd, exactly that. And being a US citizen or a green card holder makes you a US person for tax purposes, right? Okay. So the RRSP. The RRSP is generally the easiest of these because it's very close to the US 401k and related plans. Okay, and really you'll see this if you see anything in a 401 or 403 plan. Okay, so you run into any of those, they're very similar plans. Okay, and what happens here is that our tax treaty generally recognizes these as equivalent. Okay. However, again, you still want to make sure with your tax team at your investment dealer that everything is sorted out so that you're not creating double taxation for this person. We can still have the PIFIC rules apply. Okay. And then where this gets complicated is the TFSA, our ESP, and our DSP. And here, either there are no equivalents in the US or the equivalents aren't close enough to the Canadian equivalent plans. There are kind of rough equivalents. The TFSA is close-ish to the IRA, sorry, the individual retirement account, but it's not close enough. Okay, the RESP is close to the 529 plan, but not close enough. And the RDSP is close to the ABLE plan, but not close enough. Yeah, there's actually 3 different versions of the IRA, Esther. There's the IRA, the Roth IRA, and then there's another that I don't remember the name of, sorry. Okay. So they're all similar, but not similar enough. That's good. So the problem here is that your investments in these accounts may be subject to US tax and US withholding tax. Okay. But there's no way to recover that because there's no Canadian tax payable. Okay, that's good. And then the other one that I'll mention and this one's such a nightmare. If you have a US person with a Canadian corporation, okay, I will say essentially you cannot do any of the holdco or investing stuff that we talked about earlier. It doesn't work, okay? You'll probably subject this person to double taxation. And the best thing about this is the name of the rules. The rules around this are called the GILTI rules. Okay, the Global Intangible Low Taxed Income Rules. Okay. And basically what happens here is when a Canadian uses, and we talked about this a little bit last time. Somebody asked me the question before about US tax rates versus, I think it was Andrew, versus Canadian tax rates. And I said, US corporate tax rates are quite a bit higher than Canadian corporate tax rates. And this is exactly the problem, is because our tax rates are so much lower that you can end up offside on the GILTI regime and end up with a form of double taxation. Okay, that's all good? All right, perfect. I will mention, I guess I've got it up here. I might as well show you one more thing, that if you have a US shareholder of a Canadian corporation, I think I might have mentioned this once before. Okay, US shareholder of a Canadian corporation. That person cannot receive tax-free capital dividends. Okay, if they do get tax-free capital dividends, they are tax-free under Canadian tax law. That's fine. Canada will not tax them, but they're taxable income under American law, and they're not recognized under tax treaty.
I ran into this with a client in Saskatchewan with a farm. And it was a family farm that people own, and some of the owners live in the US. And they had some type of bond structure, which I haven't seen it, but it was with someone else. And they were receiving income, and I believe it was tax-free like that. And then the US government came back on them. They had to pay huge tax and penalties. It was like, it was
Yeah, because
really
you're
bad.
you're not declaring income, and they'll hammer you for not declaring that income. Yeah.
And now I got, there's clients that have TFSAs and they're leaving them money to the US, and they're like freaking out. Oh, it can't be in TFSAs. I'm like, it's in TFSAs, so it's not probatable. It's just going to be paid to you. And then they're like, well, we're going to have to pay taxes. I'm like, well, you're going to have to pay taxes no matter what. So having it in a TFSA with, a Canadian, and then when they pass away, it'll just be paid directly to you, no probate. But it's funny, they don't understand. So
Right. If you're leaving it to a US beneficiary, no problem, right? The US person holding a TFSA is still a little bit tax efficient, but you lose some of that tax efficiency. I would generally just stay away from it, only because the additional reporting is such a headache.
but when the person dies in Canada that owns it, so their mother, when they pay out that money to the son in the States, yes, he's going to have to pay taxes on that if it's taxable in the US. It's just the reason why you want it in it, so it doesn't go through probate.
Yeah. And if she's not an American, I don't think he'll end up paying any taxes on it. So the Americans do it for the dead person. It's a gift tax or an inheritance tax. Or sorry, gift tax or an estate tax. It's not actually an inheritance tax.
But if he receives money from here through anything, even if it's an inheritance, that he's saying he still has to pay tax on. That's what some lawyer that he's working with said. So I have no idea. I'm not good on tax. So
Doesn't sound right to me, but what do I know? All right. Okay. So I do have a little chart here. This is pulled straight out of the textbook that just compares the different types of plans here. Just gives you a little bit of lexicon under which to compare these two things. Okay. And I think it's an okay summary of the different plans. All right. Can we take a coffee break there? We'll take coffee there. I've got 19 minutes past. Take a 15-minute break. And we only have pensions to do now after the break. Good. So we will resume at 34 minutes past. Okay, we'll see you back then. Thanks.